PVL 2601. Contents of an antenuptial contract. The parties may include any provision in their antenuptial contract which is not impossible or contrary to law, good morals, or the nature of marriage. Essentially, it is the effect and not merely the fact of agreement which must be assessed. The matrimonial property system. Most antenuptial contracts exclude community of property and separate the property. Right of recourse in respect of household necessaries. Section 23 of the Matrimonial Property Act governs liability for household necessaries in marriages out of community of property. It provides that, as against third parties, the spouses are jointly and severally liable for debts for household necessaries, irrespective of which of them originally incurred the debt. The spouses are obliged to contribute to expenses for household necessaries on a pro rata basis, proportionately according to their respective means. If one spouse contributed more, or has contributed more than his or her pro rata share, he or she has a right of recourse against the other spouse if the marriage was concluded before the coming into operation of the Matrimonial Property Act. In marriages concluded after the coming into operation of the Matrimonial Property Act, there is no automatic right of recourse, but the spouses may agree that they nevertheless have a right of recourse against one another. Succession. In their antenuptial contract, the spouses may agree on the devolution of their estates after their respective deaths. This is called a pactum successorium, and the only pactum successorium recognized in law. Repeat, in their antenuptial contract, the spouses may agree on the devolution of their estates after their respective deaths. This is called the pactum successorium and the only pactum successorium recognized in law. In order to amend such a succession clause, the amendment must be made by means of a will made jointly between the spouses. If the spouses do make a will, the surviving spouse has the choice of inheriting either in terms of the pactum successorium or the will. Marriage settlements. A marriage settlement is a donation which one spouse makes to another in terms of an antenuptial contract. A marriage settlement may be subject to a time clause or condition. A marriage settlement may be subject to a time clause or condition. A reversion clause is generally included in respect of a marriage settlement. In a reversion clause, the donor stipulates an event upon which the donor will revert to him or her, for example, if the beneficiary predeceases the donor. The clause is enforceable, provided it does not violate the institution of marriage or its sanctity. In principle, a marriage settlement becomes irrevocable when the marriage takes place. However, because the prohibition on donations between spouses has been abolished, spouses can freely agree to cancel and amend a marriage settlement. If they cannot reach agreement the donation specified in the antenuptial contract must be carried out unless the court orders an amendment of the marriage settlement. Prior to the entry into force of the Matrimonial Property Act, marriage settlements were common, as they were exempt from the prohibition on donations between spouses. Because of the abolition of the prohibition, spousal donations need no longer be included in an antenuptial contract. The only advantage of including a donation in the antenuptial contract is that such inclusion confers some protection on the donation in the case of insolvency. Interpretation of an antenuptial contract. Interpreted in exactly the same way as any other contract, the intention of the spouses must be clear. Every legal consequence which is neither explicitly nor tacitly excluded is retained pursuant to common law or statute. Interpretation of an antenuptial contract. Interpreted in exactly the same way as any other contract, the intention of the spouses must be clear. Every legal consequence which is neither explicitly nor tacitly excluded is retained pursuant to the common law or statute. The cancellation and amendment of an antenuptial contract. Parties can cancel or amend their antenuptial contract right up to until the wedding. Once the wedding has taken place, the parties cannot cancel or amend the antenuptial contract, subject to the condition that postnuptial alterations operate only as between the spouses. Section 21(2) of the Matrimonial Property Act did make provision for a transitional period during which spouses who married before the coming into operation of the Act with an antenuptial contract excluded community of property and community of profit and loss could make the accrual system applicable to their marriage without the intervention of the court by the mere execution and registration of a notarial contract to that effect. The transitional period existed up until the 1st of November 1988. If the spouses appoint a third party as heir or legatee in their antenuptial contract, and the third party is a party to the antenuptial contract. If spouses appoint a third party as heir or legatee in their antenuptial contract, and the third party is a party to the antenuptial contract, they cannot revoke the third party's benefit without his or her consent. If the third party is not a party to the antenuptial contract, but has already accepted the benefit of the antenuptial contract, confers on him or her, the spouses likewise cannot revoke the succession clause without the third party's consent. In all other cases, the spouses can revoke or amend the third party's benefit by means of a joint will. Repeat, in all other cases, the spouses can revoke or amend the third party's benefit by means of a joint will. An antenuptial contract can also be amended or rectified by the High Court if it does not properly convey the terms of the parties' actual agreement. Repeat, an antenuptial contract can also be amended or rectified by the High Court if it does not properly convey the terms of the parties' actual agreement. If the third party is not a party to the antenuptial contract but has already accepted the benefit of the antenuptial contract, confers on him or her, the spouses likewise cannot revoke the succession clause without the third party's consent. In all other cases, the spouses can revoke or amend the third party's benefit by means of a joint will. An antenuptial contract can also be amended or rectified by the High Court if it does not properly convey the terms of the parties' actual agreement. Repeat, an antenuptial contract can be amended or rectified by the High Court if it does not properly convey the terms of the parties' actual agreement. Termination of an antenuptial contract. An antenuptial contract does not lapse on dissolution of the spouse's marriage. The antenuptial contract comes to an end only when all the contractual obligations have been fulfilled. Marriage out of community of property and community of profit and loss without the accrual system, which is a complete separation of property. Repeat, marriage out of community of property and community of profit and loss without the accrual system. A complete separation of property. Since the coming into operation of the Matrimonial Property Act, a marriage which is entered into with an antenuptial contract which excludes community of property and community of profit and loss is automatically subject to the accrual system. If the spouses do not wish the accrual system to apply to their marriage, they therefore have to stipulate this in their antenuptial contract. Repeat, if the spouses do not wish the accrual system to apply to the marriage, they have to therefore stipulate this in their antenuptial contract. In marriages out of community of property and community of profit and loss without the accrual system, a complete separation of property arises. In such a marriage, each spouse has full capacity to act and can enter into contract without the other's assistance. The spouses can also freely enter into contracts with each other. The spouses are not liable for each other's contractual debts, as each spouse binds only himself or herself. The spouses are not liable for each other's delicts and can sue each other delictually. Husband and wife have full capacity to litigate and can independently institute or defend legal proceedings. Marriage out of community of property with retention of community of profit and loss. Each spouse retains the assets he or she owns at the time of the wedding and remains separately liable for his or her antenuptial debts. Donations, bequests, inheritances, which are received during the subsistence of the marriage remain the separate property of the spouse who receives them. In this regard, the position is exactly the same as in a marriage which is subject to complete separation of property. However, because community of profit and loss is retained, all profit and loss arising during the marriage becomes joint profit and loss and constitute a joint estate owned in undivided half share by each spouse. Main differences between marriage out of community of property with retention of community of profit and loss and the main difference between marriage out of community of property with retention of community of profit and loss and the accrual system are that in the case of community of profit and loss, the spouses share post-nuptial gains and losses, and this sharing occurs during the subsistence of the marriage. Under the accrual system, on the other hand, only profits are shared, and sharing only takes place upon dissolution of the marriage. The accrual system. Prior to the commencement of the Matrimonial Property Act, most antenuptial contracts provided for complete separation of property. The matrimonial property system often proved very prejudicial to the wife if she was a housewife and mother who was unable to accumulate her estate. She could find herself in a most unfavorable financial position upon dissolution of the marriage. Her husband could completely disinherit her, and she had no claim for maintenance against the estate, and so on. The accrual system is an attempt to address this. The accrual system is founded on the notion that at the dissolution of the marriage out of community of property and community of profit and loss, both spouses ought to share in the growth of their estates, have shown, without there having been a joint estate during the subsistence of the marriage. Marriages to which the accrual system applies. Section 2 of the Matrimonial Property Act provides that the accrual system applies to all marriages which are concluded out of community of property and community of profit and loss after the coming into operation of the Act, unless this system is expressly excluded in the couple's antenuptial contract. Repeat. Marriages to which the accrual system